Good morning, all. I hope you had a good evening. Before we get started, we have a new court reporter, which I will now swear in. Sir, do you solemnly swear that you will faithfully and accurately report the present proceedings to the best of your ability as directed by the presiding officer herein?
I do.
Thank you. And are there any other preliminary matters that the parties would like to discuss before we get started?
Mr. Chair, disciplinary counsel and I discussed exhibits yesterday and admission of the exhibits. And I had introduced disciplinary counsel exhibit 2, but I don't believe I moved its admission. I was going to wait and see if disciplinary counsel did, but just for purposes of a cleaner record, if it is okay with you, I will move its admission now. And that way we don't have to keep track as we move forward.
Okay, this is petitioners 2?
It was disciplinary counsel's 2, but I introduced it with
Okay.
the Squillacote.
Okay, and I take it there's obviously no objection. So
No objection, and I believe it's technically already in the record because it's the questionnaire to the petition, but no objection.
Great, thanks for keeping this clean for me so we don't have any sort of disputes at the end. So with that, I believe, Mr. Perry, it's your witness.
Thank you, Mr. Chairman. Good morning, Ms. Squillacote.
Good morning, Mr. Perry.
And can I ask, I'm sorry, Mr. Chairman, is the audio seem to be better today?
Yes,
Okay.
no problem.
All right. Ms. Squillacote, I'm just going to try to kind of pick up the timeline where we left off yesterday. By 1991, you were employed with the Department of Defense, correct?
Late that year, yes. The college, I don't know if it was DOD or Department of Army. I'm not sure how it would be referred to, but yes.
Okay. And Lothar, Mr. Ziemer, he was arrested in 1992, correct?
I believe that to be the case, early 92.
Yesterday, we discussed your overseas travel, and we talked about an initial trip in 1979. Do you recall that?
Yes.
And I believe your testimony was that on that first trip, it wasn't Mr. Ziemer that you met.
No, it was a gentleman named Dietrich in Paris.
Okay, and that gentleman, he was also from the HVA?
I think he was like a civilian, but I think he had some kind of association with them. I don't know. I think he had some kind of association with them, yes.
Okay.
Not to the extent of, being like staffer like Lothar was.
Okay.
I think it was a more tangential relationship, but I don't remember completely.
Okay. Back to after Mr. Ziemer's arrest, you, your ex-husband, and Mr. Clark, you started talking about the possibility of future intelligence work in other nations, correct?
That's a kind of a bit of a stretch. I mean, I guess in 92, we eventually found out about him being arrested, and we were kind of really sort of watching that for some months. And then I was, distraught because, of course, I was, sort of had this personal involvement with him. And I don't know that we've talked about working with other countries. Yeah, I'm not quite, I don't mean to be evasive. I'm just trying to figure out how I would find that in my timeline. I think maybe the next year or something like that. I mean, certainly it wasn't like, oh gee, you know, the next few weeks later, oh yeah, well, let's go. I mean, it might have been something that evolved over the course of a year, maybe year and a half, something like that. So it wasn't this overt where we got together and said, oh yeah, well, let's go find another place to work with.
You did travel in January 1994 to meet with David Trong, correct?
That's right, by myself. I mean, I didn't do that. I don't even think I did that in conjunction with Clark. I don't even remember if I told him about it. I mean, my husband knew.
And you knew Mr. Trong from college?
From, yeah, the early 1970s, he'd been charged with espionage, and there were some civil liberty issues involved, and we did support work for him on the Milwaukee campus, or had him come speak on the civil liberties issues.
Now, by April 1994, you had secret level security clearance, correct?
Yes.
Okay, and if I could just take you to Disciplinary Council Exhibit 22. And go to page Bates 2 of this. And this document just memorializes that clearance, correct?
Yes.
Okay. I'd move to admit Disciplinary Council Exhibit 22.
No objection.
And actually, while we're around there, if I can pull up Disciplinary Council Exhibit 21.
Joe, I think we just need to wait for the chair to make a ruling on the admission.
Oh, I'm sorry, Mr. Chairman.
Just to make sure it's there on the record.
I ruled, but I was muted, admitted.
Apologies.
I apologize.
This Disciplinary Council Exhibit 21, if we can go to Bates 2 of this document. And this is a certification of review that you signed in connection with your employment, correct?
Yes, sir.
And it's certifying that you reviewed the survival handbook?
Yes, sir.
And you're where the handbook addressed protecting classified information, correct?
Yes, sir.
Okay. And I would move to admit Disciplinary Council Exhibit 21.
No objection.
Admitted.
And after you visited Mr. Trong, it's fair to say nothing ultimately came of that meeting?
No, nothing came of it. I mean, it wasn't a situation where I had gone to him to sort of make a proposal or to say, you know, let's do X or Y. I met with his wife, we had dinner, we kind of talked about my kids, and I talked about the position I was in and some of the things I was learning in terms of sort of the two-war strategy and political concepts I was learning from the work I was doing.
So after the meeting with Mr. Trong, ultimately you wrote a letter to the Deputy Minister of Defense for South Africa, correct?
Correct.
And that's Mr. Ronnie Casrills, correct?
Yes, yes.
Okay. And if we can go to Disciplinary Council Exhibit 26. And this is that letter, correct?
Yes, sir.
This was in around the summer of 1995?
I believe that's correct, June.
We move to admit Disciplinary Council Exhibit 26.
Objection.
There was no objection?
Yes, Mr. Chair, no
no-
objection.
Okay, admitted.
And Mr. Casrills responded, correct?
I believe, yes, that holiday season, he sent a Christmas card.
Okay. And if we could go to Disciplinary Council Exhibit 27. and go to page Bates 2. I'm sorry. This is part of the Christmas card, correct?
I believe so. I don't remember specifically, but I think that's certainly was his handwriting on the front, I believe.
And that handwriting, it listed the P.O. box set up under the name Lisa Martin, correct?
Yes, that's how I had sent it.
Okay. And we'd move to admit disciplinary council exhibit 27.
No objection.
Admitted.
Now that, and we could take that down, that Christmas card was actually from Mr. Casseroles, correct?
Correct.
Okay, but then later, the FBI responds as part of the undercover sting, posing as Mr. Casseroles, correct?
Correct.
And they sent you a letter, correct?
Correct.
All right, and if we can go to disciplinary council exhibit 29. And go to, and we see here this letter is addressed to the P.O. box again, correct?
Correct.
And go to Bates 2. And so this is the letter that was part of the sting operation, correct?
Initiated it, yes, with me.
Okay. And so we've moved to admit 29.
No objection.
Admitted.
And here, the FBI posing as Mr. Casseroles is asking you to meet with one of his special components, correct?
Yes.
And the letter asks that you travel to New York on October 12th, correct?
Yes.
And we can take that down. You did travel to New York on October 12th, 1996, correct?
Yes.
And that's where you met with the undercover agent?
Yes.
And he asked you to write a report about information you might have access to, correct?
I think maybe it was broader than that. The meeting, the discussion kind of went a sort of chaotic course. The sort of the transcript is kind of somewhat confusing in terms of, well, what is it I'm wanting? What is it he's wanting? What is your background? So on. And so what did you expect? So on. And then he said, well, we need to examine you for your suitability. And at that point, I'd already, I think, told him at the end of the first conversation, yes, we have this background. We have this contact with the former East Germany. And so he was like, well, tell me about that. And how you might be of service to us, right? So he had said, I had given him the study group outline and discussed things like that. And he was, well, we need scoops. And so he was like, what's your suitability? How can you help us in this area? So it was broad ranging. I don't think it was just what information do you have access to? It was sort of bigger than that.
He never asked you to bring him documents, correct?
He never asked me to bring him documents, did you say?
Yes.
No, I would not say that. I would think it's a fair statement to say that it was indicated in the first meeting that, as he said, they had journalists who could do political stuff and they wanted scoops, was his phrase. But that's not, a direct invitation. Please give me documents the next time we meet.
You agreed to provide a report on a computer disk that you were to deliver to a P.O. box.
Yes,
correct?
sir.
Okay.
Yes, sir.
At the end of the meeting with that undercover agent, you accepted $1,000 payment, correct?
Yes, for the expenses, yes.
And that is not the only time you'd accept money from the agent, correct?
From him or from any agent? You mean from Lotar or?
No, I'm sorry, in connection with the undercover operation.
I guess not. I think there must have been some reimbursement later in the Atlanta trip, maybe. I don't have a clear memory, but I would imagine there would be.
And you did, in fact, deliver a report to the undercover agent on a disk, correct?
Yes, sir.
Okay, and if we could go to what's already been admitted, Disciplinary Council Exhibit 36. This is that report, correct?
Yes, sir.
Okay, we can take that down. I want to turn to the documents that you gave to the agent, and we're talking about 4 documents that were classified as secret, correct?
Yes, parts of which were classified, yes.
And I want to go to Disciplinary Council Exhibit 5. And you recognize this as the indictment from your case, correct?
Yes, sir.
And if we can go to Bates 37 of that document. And please let me know if you want time to review anything as I'm asking questions. I'm operating under the assumption that you've reviewed at least some of this.
Yes, sir.
But so the first document was entitled Defense Planning Guidance Scenario Appendix. And that's fiscal
Yes.
year 1998 to 2003.
Yes.
Now, you agree that this document discussed potential U.S. military responses to various threat scenarios, correct?
Yes.
And you agree that this document bore instructions that it should not be reproduced without Secretary of Defense approval, correct?
Yes, sir.
Okay. And if we can zoom out, the second document, it starts on 37. It's called Defense Planning Guidance for fiscal year 97 to 2001.
Yes.
And you agree that this document discussed department policy guidance on issues related to national security.
Yes, sir.
And in addition to being classified as secret, this document bore its NOFORN label, which means it should not be distributed to non-US government persons or countries, correct?
I believe that's correct.
And if we can go now to the third document. The third document that you turned over was a draft document, Defense Planning Guidance for fiscal year 96 through 01.
Yes.
And it just set forth strategy, plans, and programs to guide the Department of Defense and was related to the national defense, correct?
Yes.
And then finally, the fourth document, International Arms Trade Report, September, October 94. Now, this particular document was an intelligence memorandum issued by the CIA about arms trade, correct?
Yes.
And that also bore that NOFORN designation, correct?
Yes, sir.
Now, before providing the documents to the undercover agent, you and your ex-husband altered the documents by removing the secret labels, correct?
Yes. On some of them, yes.
And you also cut off the tops and bottoms of some of the pages?
Yes, sir.
And then you burned meaning you, I'm excluding your husband from this question. You burned the scraps of paper that were produced by doing all the trimming?
Yes, sir.
Disciplinary counsel would move to admit 5, the indictment.
No objection.
Admitted.
After you did that to the documents, you then debated how you were going to give them to who you did not know was an undercover agent, correct?
With my husband, I think, yes, I had those conversations.
And one of the things you did was purchase a scanner?
Yes. I believe I did that. To be honest, I don't have a clear direct memory of any of this, but I know that was put into evidence, so I'm certain I did so.
Okay, if we could go to Disciplinary Counsel Exhibit 37. Now, this is a transcript of a phone call between you and your ex-husband, correct?
Yes, sir.
And we're at January 4th, so one day before you were going to meet with the undercover agent, correct?
I don't remember what day I met with him, but certainly within a couple days.
Okay. If we can turn, and you see that this transcript was admitted at your underlying criminal trial, correct?
Yes, sir.
Good. Move to admit 37.
No objection.
Admitted.
And if we could go to Bates 2 on this first. And here, I apologize, it's starting in the middle of one of your statements. But at the top there, it says, I'm going to test it out and see if I'm really confident that I'm not leaving any trail on my hard drive anywhere. You see that?
Yes, sir.
So there you're debating, or I guess you're concerned that use of the scanner might leave evidence on the hard drive of your computer, correct?
Yes, sir.
Mr. Perry, could you go to the sentence before that so I can see the context?
Absolutely. And maybe from Mr. Stan's, oh, you did buy a scanner would be, thank you.
Where are you?
So starting at Bates 1, Mr. Stan says, oh, you did buy a scanner. And then in response, Ms. Squillacote says, yeah, I'm not sure how I want to do it. And then that carries on to the next page, I'm not sure. And then she discusses testing it out and not leaving a trail on a hard drive.
Okay. All right.
Okay. And if going back to page 1 of this exhibit, and right under the 3 asterisks, if we could enlarge that paragraph from Ms. Squillacote. Now here, in addition to talking about the scanner, you're talking about an appointment with Dr. Apud?
Yeah, my psychiatrist.
He was your psychiatrist at this time?
Yes, sir.
So according to this, at least, it looks like you bought the scanner on the way back from an appointment with your treating psychiatrist at the time.
That's what it says. I don't have a firsthand memory of this. I just don't remember, for example, going to the appointment and then going and doing this. I don't have my own personal memory, but that is what it states.
Okay. If we can go to Disciplinary Council Exhibit 38. And this is a transcript of another call between your ex-husband and yourself, correct?
Yes, sir.
And the date here is January 5th.
Yes, sir.
And if we can turn to page 3. And if we can enlarge, starting with, I mean, I got to bed, that statement and the following statement. That's
yes.
fine.
Yes.
So here you're discussing the burning of the confidential markings, correct?
Yes.
And then if we can go to the last 2 transcribed lines, I forgot, starting with I forgot. And you're discussing your medication here as well.
Yeah, I had started the Zoloft, gosh, the summer or fall before, and it was somewhat, I'd started it, stopped it. I had a bit of a reaction. It was a little erratic, my use of the antidepressant. And I think apparently I'd forgotten to take it that day. I don't know what the other stuff refers to. It might have been I don't know, it might have been trazodone or something, I'm not sure. It was another medication.
We would move to admit disciplinary counsel exhibit 38.
No objection.
Admitted.
So around this time, you meet with the undercover agent and provide him the altered documents, correct?
Yes, the documents and a book I gave him.
And shortly after that meeting, you resigned, correct?
Correct.
And upon your resignation, you had to sign a security termination statement
Yes, sir.
about not revealing secret information.
Not having any in my possession, I think was the statement.
Okay. And that was the basis for the false statement conviction in your case, correct?
Yes, sir.
You met with the undercover agent at least 2 more times, correct?
March
All
and March, maybe one more time. Is that, would that be correct?
I'm sorry, I should have been more precise in my question. There was a meeting in March 29th, 1997, and it without knowing the timing, it looked like 2 meets on one day.
Yes, that's right. I met with him in the morning, and then my husband and kids and I met with him later that day. So that would be correct. I mean, they were separate.
So the first meeting in the morning was just you, correct?
Yes.
And one of the things that you did at that meeting was recommend to the undercover agent that you bring your ex-husband along, correct?
That he meet with him. Yeah, Kurt was already with me with the kids, and I think, you know, he and I had already discussed, gee, you should meet this guy or something. Yeah, but I think I suggested it to the undercover agent.
And after that meeting, after that one day of 2 meetings, you continued your correspondence with the undercover agent, correct?
We had several other written communications through the summer, I think.
Okay. And
Summer,
again,
September, early September, I think.
okay. And again, understanding that you looked at these documents, I'm just going to try to run through those. If we can go through to disciplinary counsel exhibit 42.
Yes.
This is a May 10th, 97 letter from you to the agent, correct?
Yes.
We'll move to admit 42.
No objection.
Admitted.
And then if we can go to 43. This is a response from the FBI, who you still thought was Mr. Casserole, correct?
Yeah, I mean, I wasn't sure at that point, but who they were, I think the point of the correspondence might have been, I don't really know who you are, but I think, yes, eventually it was. Yeah, this is a little unclear to me when I was going over your exhibits. I think they'd shown me some kind of photos, and it caused my husband and I to sort of be like confused about what was going on in some fashion. Honestly, Mr. Perry, I don't remember the exact specifics of what was confusing us, but that's sort of what this back and forth was about.
Counsel, can we clear up, this letter is addressed to Anne. Could we find out who Anne was?
Yes, and that's what I guess my next 2 questions. First, Anne is one of the false names that you used, correct?
I think what happened is at the first meeting with the undercover agent, or the second one, he said, how should we, let's have a name to use with you. And I think we chose Anne. That's my recollection. But I understood that that was his name to speak to me.
Yes, and then so this, what we're looking at right now was his response to you, correct?
Yes.
Okay. It would move to admit exhibit 43.
No objection.
Admitted.
And if we go to 44. And if we can just, yeah, enlarge that, please. Now, this is a response back to him with you signing as Ann, correct?
Yes, sir.
And move to admit 44.
No objection.
Admitted.
And if we can go to 45. Now, this is, again, addressed to Ann, meaning you, correct?
Yes, sir.
And this is scheduling a meeting for October 4th, correct?
Yeah, they said that someone very, very senior was coming from Mr. Casril's and wanted to meet with us.
And just for context, we're very close to the time of your arrest, correct?
Yes, that's the meeting that this is setting up.
Okay. Move to admit 45.
No objection.
Admitted.
And Ms. Squillacote, you sent one more letter before that scheduled meeting date, correct?
I think so.
And if we can go to 46. Is this that letter?
Yes.
We'll move to admit 46.
No objection.
Admitted.
And we can take that down. And I apologize, it's a bit of repetition, but you were arrested in October 1997, correct?
October 4th, yes.
I want to transition now to put a little more focus on some of the mental health issues that have been discussed.
Yes, sir.
And specifically at your criminal trial, one of your witnesses who testified for you was Dr. Janofsky, right?
Jeff Janofsky, yes.
And just in general terms, is it fair to say he testified about how you suffered from major depression?
Major depression, and I think also the personality disorders was a big focus for all of the psychiatric witnesses.
Now, the borderline personality disorder
Yeah.
is one, correct?
Borderline, narcissistic, histrionic, sort of this cluster B group.
Now, we would move to admit Petitioners 27, which is a transcript of Dr. Janofsky's testimony.
No objection.
Petitioners. Admitted.
Now, Ms. Squillacote, you're aware that in disciplinary counsel's exhibits, there's two transcripts of recordings of calls that involve your attempts, as you phrased it, to clean up your credit report, correct?
Yes, sir.
And you're aware that Dr. Janofsky testified regarding these recordings?
I don't have a specific memory of it. I don't think I read through those exhibits line by line, but I would not be surprised, and I would expect that would have been something he would have addressed.
Mr. Perry, I'm sorry to jump in, but I think you said Petitioner's Exhibit 26, and I agree, but I think it is Petitioner's Exhibit 27, just for purposes of the record.
Thank you. I intended to say 27.
I thought you said 27 as well.
Okay, maybe I just wrote a clerical error. My apologies.
So specifically in these calls that we're talking about, these recordings, they're calls with your brother discussing dishonest things you did to clean up your credit report, correct?
Yes.
And
yes, I'm sort of hysterically kind of laughing about what look at this stupid idiot, stuff, and how crazy this was, and he's laughing and I'm laughing, and yes. But yes, I was trying to get rid of some late reports on our credit report, and I was kind of always sort of perennially drowning in financial mess, I guess. And I was trying to clean this up and had come up with this outlandish, stupid, and fraudulent scheme to do so.
Well, in one of the calls, you talk about creating fake stationery to make it appear like it was a letter from Crestar Bank, correct?
I think so, yes.
And in another call regarding the same topic, you talk about how you have such a nice sounding voice and how you can make yourself sound 12 years old, correct?
I don't remember that, but if it's in the transcript, I said it.
Disciplinary counsel would move to admit Exhibit 30 and 31, which are transcripts of the calls just referenced.
So first on disciplinary counsel Exhibit 30.
30, no objection.
Admitted. And 31.
No objection.
Admitted.
Also, at your criminal trial, I believe it's Dr. and the pronunciation Plakin.
Plakin?
Thank you. Dr. Plakin testified on your behalf at trial regarding your mental health issues, correct?
Yes, sir.
And he described it as a very complicated case, correct?
I don't remember that, but I'm sure I wouldn't be surprised if he said that.
And in addition to kind of the same diagnoses that Dr. Janowski discussed, Dr. Plakin, he also discussed, and again, I'm not sure in the pronunciation, but something you deal with, Ehlers-Danlos syndrome?
Ehlers-Danlos syndrome, a connective tissue disorder.
Okay.
We weren't sure at the time. We kind of thought that's what we had. And since in 2016, actually here, we were confirmed it genetically, yes.
Confirm that you do suffer from it.
Yes, and then
Okay.
it turns out we all do, yeah.
And in his testimony, do you recall generally the doctor talking about that having an effect on your psychological makeup? Well,
I don't remember that specific reference. I wouldn't be surprised if it's there. I guess I looked through them, but it's not jumping out at me right now.
disciplinary counsel would move to admit petitioners 28, which is a transcript of Dr. Plakin's testimony at trial.
No objection.
Admitted.
I want to discuss, now we're post-conviction.
Yes, sir.
And one thing, I'm not sure if I heard correctly yesterday in your testimony. Did you testify that you may have had 4 or 5 disciplinary write-ups while incarcerated?
Shots? Yes, I'm sure I got shot for having my kit bag on the locker, for having some kitchen food in the room, for missing a call out, things like that. I think
Okay.
I might have had, I don't know, 4 or 5 over the 20 years.
Okay, and I'm sorry, did you call them shots?
Yeah, that's our federal inmate term. They call them shots. I can't even remember what they're officially called, but we call them shots.
Okay. In terms of what was happening with your legal case, and I'm going to go into the appeals now. And again, just going through documents quickly. But first, you appealed your conviction, correct?
Yes, sir.
All right. And if we can go to Disciplinary Counsel Exhibit 8. Yeah, that's your notice of appeal, correct?
Yes, sir.
Okay. If you move to admit 8.
No objection.
Admitted.
We'll go to 9. And this has already been admitted, but this is the Fourth Circuit denial of your appeal, correct?
Yes, sir.
And after this, you filed a motion to vacate sentence, correct?
Yes, sir.
And if we can go to Disciplinary Council Exhibit 10. And this is a Fourth Circuit remand to the Eastern District in connection with your motion to vacate, correct?
Yes, sir.
We'll move to admit 10.
No objection.
Admitted.
And if we could go to 11, please. And this is the findings of fact and conclusions of law upon remand, correct?
Yes, sir.
We'll move to admit 11, please.
No objection.
Admitted.
And if we can go to 12. And now the next thing you did after the findings on remand, you sought a certificate of appealability from the Fourth Circuit, correct?
Yes, sir.
And this, obviously the cover page of Disciplinary Council Exhibit 12 is a motion to substitute the corrected copy. But if we go to the next page, underneath that is your informal brief that you filed, correct?
Yes, sir.
Okay, I would move to admit 12.
No objection.
Admitted.
And we can see by looking at the top line there, the pacer line in red, that this was filed in 2009, correct?
Yes, sir.
And if we could go to Bates 6 of this document. Now, if we just enlarge down where it says Roman numeral 2, all the way down, just enlarge that portion of the page. Oh, yeah, just on the first page there. I just need the first sentence. Thank you. Here in this 2009 filing, you reference an April 15th, 2002 affidavit, correct?
Yes, sir.
And that affidavit says what you would have said if you had testified, correct?
Yes, sir.
Okay. If we can pull up Petitioner's Exhibit 24. This is the affidavit that 2009 filing is referring to, correct?
Yes, sir.
We move to admit Petitioner's 24.
Objection.
Okay, and just so you know, I'm going to come back to this affidavit.
Wait,
But-
hold on. I just want to make sure that on my audio, it wasn't clear whether that was objection or no objection. I just wanted to make sure whether the court reporter picked it up.
Just for clarity, it was a no objection.
Okay. And I also didn't hear the chair's ruling. I don't think it came through.
It didn't come through because I didn't say it.
Okay.
Before I was going to rule, you started talking, Mr. Perry.
I apologize, Mr. Chairman.
Yeah, it's admitted, but you said you were going to tie it up later. Yeah, the document's admitted. Go ahead.
So I will come back to this document, but I'm just to finish out the procedural history, Ms. Squillacote. The Fourth Circuit did not issue a certificate of appealability, correct?
Correct.
And if we can go to 13. And that's the denial of their certificate of appealability, correct?
Correct.
Okay.
So we would move to admit.
Back and forth. This is disciplinary council 13.
Yes, sir.
Okay.
And we would move to admit disciplinary council exhibit 13.
No objection.
Admitted.
Okay. And after this, you filed a petition for rehearing.
Correct.
And that, if we could go to disciplinary council exhibit 14. And that is your petition for rehearing, correct?
Yes, sir.
And we move to admit 14.
No objection.
Admitted.
And finally, your petition for rehearing en banc was denied, correct?
Yes, sir.
And go to disciplinary council exhibit 15. And this is that denial, correct?
Yes, sir.
And we would move to admit disciplinary council exhibit 15.
No objection.
Admitted.
So, Ms. Squillacote and everyone, thank you for bearing with me through that. I now just want to take you back to that April 2002 affidavit, petitioner's exhibit 24.
Yes, sir.
Now, this was signed under penalty of perjury, correct?
Yes, sir.
And if we can go to what's marked as Bates 137 on this document. And then the first line of paragraph 13, you assert that my professional choices were innocent, correct?
Yes, sir.
No, we could take that down. Finally, after an arrest, you did, and I think it's fair to say, did an interview with 60 Minutes, correct?
Yes, sir.
And it was part of a broader story about FISA and
Yes.
and your case generally, correct?
Yes, sir.
And one of the assertions you made in there was I was never a spy, correct?
Yes, sir. I believe that to be the case, yes. From the transcript and so forth, yes.
So disciplinary counsel would move to admit 52, which is a transcript of the 60 Minutes interview.
Petitioner recognizes that disciplinary counsel had that video transcribed. We believe that there are certain indications not made in the video, for instance, when recordings are played and that type of thing. So we don't object to this exhibit, but we will move for our own video, the actual video, to be admitted. I can do that now, or I can do that on redirect, however the chair prefers.
Why don't we wait for redirect and hear fully what your concerns are? I'll admit it, and I understand that you're going to have your say on redirect.
So Chairman, it was also disciplinary counsel's intention to move for admission of the video as well, which is petitioner's 31. So
That may obviate the issue then. Thank you.
Are you so moving? We could do that right now.
yeah,
We'll wait for redirect. We'll wait for redirect.
so they're leaving that there and understanding that petitioner will move the video in. There's nothing further from disciplinary counsel.
Oh. Okay. Let's see. Are you ready for redirect, Ms. Williams?
I would like a brief break if
Sure.
will allow.
Why don't we go break until 10:30?
Okay. Thank you.
Thank you.
Opening up the breakout rooms now.
I also need to.
See, everybody is present. Ms. Williams, are you ready to proceed?
Can you hear?
I can't, let's see. We are unmuted, but we cannot hear at the moment. Okay,
How about
I
now?
can't hear you.
Can you hear me now? How about now? Can you hear us? Ms. Williams, can you hear me now?
Yes, I was actually just
Okay.
about to, but now I hear you. Thank you.
Okay.
Okay, Ms. Williams, are you ready to proceed?
Yes, we are ready to proceed. Ms. Squillacote, you were just asked about a 60 minutes interview, were you not?
Yes,
Okay. And you were asked about a statement of saying that you were not a spy.
yes,
Can you explain that statement?
yes. I thought we had been examining our appeal, the trial. I felt there were certain technical issues that may have precluded that legal conclusion.
And do you contend your behavior that disciplinary counsel has walked through was not illegal?
No,
Was it wrongful?
it was wrongful, and I see that it clearly crossed a line, and it's 20 some years later, it's something I wholeheartedly reject.
And how do you feel now about the statements you made in the 60 Minutes interview and your review of your conduct?
I think at the time it was early 1999. I was processing what had happened to me. I was processing sort of the nature of the false flag, the state I was in, the response of my husband's family and friends kind of putting it all on me. And I think it reflected a lot of anger and bitterness.
Petitioner would move for admission of Petitioner's Exhibit 31, which is the video of the interview, which I understand there's no objection to.
No objection. Further on.
Admitted, admitted.
Ms. Squillacote, I'd like to move to Petitioner's Exhibit 24 that disciplinary counsel just discussed with you. Can we display that, please? And we're going to go to, I think, the third page of that exhibit. And you were asked about paragraph 13. Do you recall that?
Yes,
And when you were applying for jobs, were you trying to get access to classified documents to share with Mr. Ziemer or other contacts you had?
that wasn't the primary purpose of my job efforts. I was trying to further my relationship with the East Germans, but that was not necessarily meant that I was trying to get classified information.
I'd like, we can take that down, and I'd like to display now Petitioner's Exhibit 24 or 25, I apologize. And do you recognize this document?
Yes,
And what is it?
it was a stipulation submitted at trial as to my job applications during this time.
And if we scroll down to page 3, just to scroll back up one page, sorry. There's a list of kind of positions you applied for. Is that an accurate description?
Yes, some of them.
Okay. And so if we go back down to the third page and paragraph 5, reads, had defendant Squillacote been hired for any of the position, any of those agencies listed in A through T, she might have had authorized access to classified national defense information. Did I read that correctly?
Yes,
And because this is a stipulation, the government agreed with that statement. Is that correct?
yes,
Let's go to page 4, please. And paragraph 6 at the top. Each of the agencies listed in U through EE would not have provided defendant Squillacote with authorized access to classified national defense information. Did I read that correctly?
yes,
And this was also a fact that the government agreed in your trial.
yes,
Petitioner moves for admission of Petitioner's Exhibit 25.
I can't hear you, Mr. Perry.
No objection.
Admitted.
How has your mental health treatment changed since when you were being seen by Mr.
Dr. Pood. So I had sort of just begun sort of very focused psychiatric care in 95, 96. And I was struggling with sort of accepting it. I think I had resisted medication in 91, 92. I, at that point, understood that I needed it. I went on it, but I was still unsure of it. There were times I was so sort of euphoric or thrilled. For instance, when the undercover, when they initiated the invitation to come see them, I was so ecstatic that I think I stopped taking the Zoloft. I had an episode at the library that made me concerned. So it was, I think, uneven at first, but within very short order and to the present, it's been a staple in continued and consistent use of antidepressants.
And I believe in that conversation that was displayed, you were taking Zoloft at the time. Is that
Yes.
correct? And are you taking Zoloft now?
No, I'm on Wellbutrin.
Objection. Mr. Chairman, this seems to be going beyond the scope of cross, which was just that she was visiting Dr. Pood at the time of that call.
I agree with Mr. Perry, but I'll allow this question and we'll move on.
Putting together the conduct that Mr. Perry walked you through, how would you respond now?
It was horrible. It was horrible. It was egregious, serious misconduct up and down the line. I repudiate it. I apologize for it. It's not something that would even enter my consciousness at this point. It's something that has long since gone into my past. I made a comment in my petition that, you know, even if I had, say, been acquitted or been found not guilty of espionage in a narrower sense, it still is misconduct. It still is serious misconduct for the reason that you're helping a government other than your own. And that is, and you're doing it surreptitiously and so forth, that is serious wrongful misconduct. I would never engage in something duplicitous, dishonest, sneaky like that. Again, if you have an opinion, if you have a set of beliefs, put it out there, state it, argue it, live it. I would never do something like that again. I want to reiterate my apology for it to the Office of Disciplinary Counsel and to the members of the committee. I apologize. I have no excuse or justification. I'm very grateful for the opportunity to try to show to you that I'm a different person and have succeeded in becoming that over the last 25 years. Thank you.
Mr. Chair, no further questions.
Thank you, Ms. Williams. At this point, I think we'll turn it over to see if any of the committee members have questions. Ms. Smith?
Not at the moment. I may, before we leave this part of the hearing.
All right. And Ms. Bunch?
I have one question. I'll try to make it as less of a run-on sentence as possible. Ms. Squillacote, first of all, thank you for your testimony. I can't imagine that this is an easy thing for you, and appreciate that. One of the questions I guess I have, I'm trying to reconcile some of the character witnesses that talked about specifically your conduct to remedy some of the past wrongs, and to testify about what they believe is your recognition of the seriousness of your past conduct, particularly Dean Malinengo, and hope I pronounced that correctly. But when we heard some of the testimony, they didn't seem to have a lot of the details regarding the relevant past wrongs. Can you just share a little bit about what you think regarding their testimony and how you think it squares with them attesting to the fact that your conduct, or they recognize your recognition of the seriousness of your conduct without knowing some of the key details? And
Sure.
I know that was horrible, but let me know if you want me to repeat it or don't understand.
No, I understand it, and I actually appreciate that question. So the important thing for me when I was re-entering, for example, with members of St. Boniface and so forth, was to A, let them know that I was a returning felon, B, to let people know what the charge was, which that it was espionage, a related charge, and then in some fashion to give them a sense of what the facts were. It kind of depended if I was talking to a lawyer or not. I wasn't gonna, for example, with Father Joel or Mary Ellen or others, sort of walk through a lengthy timeline or give them the legal documents. I believe I gave them some published articles that had been written on it. I think there was some press, and I described to them just as I sort of would to in lay language to them what it was. And I thought that was fairly sufficient. I certainly told them it was espionage. I certainly told them it involved East Germany. I don't know that I walked through the specifics of the false flag. I believe I did communicate that I'd given documents to someone I thought was for a foreign government. And to me, that was the essence of it, and the core, sort of the wrongfulness of it. And I was open to them about it. I was open to pretty much anybody about it because I felt uncomfortable not being, right? It was like you were hiding something. With Dean Hank, and I think it might be just a different recollection, it was a long process to get the dean at that time, the interim dean, to agree to admit me. And both Miss Allgaier, the director of admissions, and Dean Hank, I gave them, for example, the direct appeal affirmance, because, well, certainly with Dean Hank, that was sort of the easiest reference. Here's the direct appeal, here's what the found facts were. But they also asked me for chronologies. So give us a timeline of what happened. And I would produce almost sort of a biographical statement. And then it was, well, tell us more about your your timeline. And I ended up producing literally something from birth all the way through date of arrest that was actually very specific and went through the sting and so forth. I think that might have been something he just didn't remember at the time, but that actually was something I provided. So I felt with those who had the legal background, I could refer to the direct appeal, and there was a lengthy period going back and forth to get material to the dean, to be very, very upfront. And it was about the case, but it was also about my childhood and my family members and so on. It was very lengthy chronology. But yes, I tried to be as open and forthright as I could without sort of, yeah, that would be my answer.
Thank you. I have no further questions at this time.
Thank you, Ms. Bunch. Ms. Squillacote, I would like to echo Ms. Bunch's appreciation for your appearing today, and I know it's been difficult for everything you've been through to listen to this today and yesterday. Our function on the committee is to determine whether you should be reinstated to practice law in the district. And this case is difficult, and I'll explain why in my mind. Your conduct from 78, 79 through 96 just was full of duplicity. And as you use the word, sneaking around and doing all kinds of stuff in your role that you were playing at the time. We have to determine today if you are free of that and able to practice law in the District of Columbia. And I'll walk you through it, but for us, that's our task, and it's not an easy one. Do you understand what I'm talking about here?
Yes, I do.
It is my belief and understanding from the testimony that you certainly possess the skills for reinstatement to be a lawyer in the district. We are going to be focusing on character and fitness because I think that this case cries out for that. So we will. Now, you have indicated that you're a changed person. And I want to focus a little bit on that process. After your conviction, you appealed the conviction at least through 2010. Is that correct?
Yes. Yeah, I had appeal related, the habeas related on the right to testify, yes.
So is it fair to assume that through those appeals, you still felt that you had not actually committed a crime?
No, I don't think that I would say that I believed I had not committed a crime. What I felt, very frankly, was that there had been, certainly in the beginning, really a lot of confusion and chaos in my view or understanding of what I was being drawn into. And that presented certain issues that could present a, sort of technical defense, if you will, to the nature of the conviction. So, I had this sort of glorified view of this highly evolved political purpose, and that we were doing analysis, and I tried in certain respects to communicate that. That's not to say that I didn't understand eventually what was being asked and what I did. I did. And if I sound like I'm trying to hedge, I don't mean to, but that is what, even still, when I go through the exhibits and I read it, I know what I'm trying to say in certain spots. And it was frustrating because I didn't stand up and say, here's what I'm trying to do. And I so much allowed myself to be kind of guided or led, if you will, and have the agenda set for me. That's not to walk away from my responsibility for my conduct, but in honest truth, I see it even now when I read it. And that presented to me, for example, in the right to testify, I a yapper, you know, like my daughter is a yapper. And I very much wanted to say, wait a minute, here's what I meant. Here's what I was trying to say. It was submerged in many respects, in some respects, not so submerged. If you parse through a lot of the transcripts of the meets and the letters, but I knew what I was trying to say. And I wanted a chance to be able to say that. And that was important to me. Just a bit. I'm sorry.
That's okay. If you'd like to take a moment.
It was important to me if I was going to be so split open, right? For the world to see, look at this horrible, sick person. If that was going to happen to me, I at least wanted the chance to be able to say, wait a minute, let me say what I want to say. And I felt like I didn't have that chance. And so I wanted it. That's not to, again, it's not to walk back my responsibility. You know, whether I had the intent to provide classified national defense or not, in a sense, it's still seriously wrongful conduct, right? Because you're trying to help, as I said, a government other than your own, and that's wrong. But I felt there was some ambiguity. And even now when I read through it, it's like, I see horrible parts. And then I see other parts where I was trying to say something different or do something different. And I guess that's why I felt unsure about the integrity of the conviction. I don't feel unsure about it now. And I never felt unsure about the wrongfulness of it. Does that answer your question?
In large part, it does. But I would like to know kind of when you came to the firm realization it was wrongful, and what was it that changed within you that today you're a different person?
Yeah, that's a two-part question. I mentioned I knew for certainty that he was part of an intelligence. Lothar worked, as I mentioned, after that, asking him after I saw that media report. I think it might have been 90 or 91. So I understood that. I understood that the difficulty for me was that I had never been clearly pushed by them, right, to go for classified material. I had been pushed repeatedly for Capitol Hill work. And there were various spots where I kept seeing that. And the nature of their discussion there, I mean, Lothar and Kurt and Kurt's parents, was always very fancy, theoretical, political, you know, powerful discussion that I was intimidated by and sought to emulate. And I did that even up until the meeting with the undercover agent, which is, you know, full of these sort of contradictory, ambiguous statements, right? I find that October 12th transcript still very conflicted. It's going in different directions, right? I say like, oh yeah, I violated Title 10. And then I say, well, between my husband's family and myself, you know, we go back in this to 1918. What did that mean? Spying? We were spying back to 1918? Yeah. It is, and well, I gave him the study group outline. It was, you know, here's what I'm interested in, that we should correct this. At the same time, I'm saying other things. I think for me personally, I clearly understood that I had crossed a line and was doing something wrong when I gave him those documents.
Okay.
Yeah, that was when it was like, I felt unclean, I felt dirty. I knew that that was not, it wasn't just making a mistake. It wasn't just doing something stupid. It was a seriously horrible thing. And up until that point, I had been trying to navigate some strange path that, as weird and bizarre as it might sound now, it was part of this sort of highfalutin, fancy elite political stuff. And I don't know if that answers your question. That's the best answer I can give you. The second part as to why it's different now. It was, and it sounds almost, I feel like almost a sissy, or, you know, yeah, right, you had mental health problems, yeah, right. Well, they were really real and serious, and it was scary for my family because as I said, my sister had committed suicide, and they were really scared that we were so close and we were the same age. They were really scared. And the thing with this personality disorder is you don't know who you are. I mean, you have no authentic sense of self, right? You're whatever that other person wants you to be. And I made the comment to my brother in one of the transcripts, I've been erased. You know, I've been erased when I thought Lothar had abandoned me. It's like you cease to exist. And it was just terrifying. And a large part I felt at the time of my impetus, frankly, in giving the documents was somehow I'll be able to get back to Lothar and I'll be strong. I'll be okay. I'll be able to balance the checkbook and get everything done and take care of everybody and do all the stuff I'm supposed to do. And yeah, and I think what was so painful about that trial and the arrest, but also what was so beneficial about it was, you know, it was right in front of my face. You can't, you're looking at it, you're looking at your conduct, you're looking at what you've said, you're looking at how you screamed at somebody, you're looking at your emotional hysterics, and you can't avoid it. You know, it would be, I'm not that kind of phony that I could just shunt it all and that wasn't really me or somehow hide. No, it was me. I own all of it. And what I feel so good about, whatever the outcome of this, those people who testified for me, they were like testifying based on the authentic me, right? Me, the real me. And they felt like they liked me and they could stand behind me. And I felt like I earned that through a lot of really hard work inside doing the psychiatric work. I mean, that CBT program really made a difference. That was
the program in prison.
Yeah, the RDAP one. That was
right.
Just, there's no excuses, no hiding. You get torn down in front of a group of 100 plus and you got to stand up and own it. And it was such a relief to be able to say to myself, I can alleviate this just by changing the way I think about something. And, you know, the whole abandonment stuff, the idea that if someone leaves me, I'm not there. Yeah, I am. I'm still here. And it was through this process of defining myself more and more and more. What are my values? What do I stand for? What do I believe in? Me. Like being able to go to mass right away, right? That was something that was forbidden in a sense, right? Like, this is trite, but it's true. There was a sports TV room and it was more private, not as hectic. And I'd sit there, and if a game came on and the anthem was played, I would stand up by myself, right? Just because, not to score points, no one's watching me. I wasn't.
When was this? Was this in prison?
Yeah. I wanted to re-grasp my love of my country. I mean, that was something I sort of very consciously did. So it was through, hearing from my children and others the kind of pain I'd caused them, working through what healthy boundaries were. So you know, it was like I had sort of a normal liberal American upbringing with some differences. The extreme hospitalization was a pretty significant thing. And my father's, we were so close on this idea of social commitment. And then meeting Kurt and just getting taken into this other land. And now I can say, and this was started soon after the arrest and soon through my process, it's not to say I didn't pursue my defense, but I worked really hard on myself, and I feel it shows.
Well, I think it does show, certainly from your character witnesses. And it appears to me that religion is an important part of your life. Is that correct?
Yes.
When you got involved with Lothar and all that, were you still religious at that time?
When I met Kurt in 78, 79, at that point I was. When I sort of became, let's say, indoctrinated or trained in Marxist thought, that was eschewed. That was regarded almost as, like I said, his family thought I was terribly bourgeois and didn't want Kurt to have any part of me for sort of that set of reasons. So no, it was like an interruption. But it literally, I mean, almost as soon as I got back in Alexandria Detention Center, I was like, when can we sign up for Mass? And yeah, it was a tremendous comfort.
Okay. There are a couple of points. I guess I just want to close out on a few of these things. There was testimony, and I hadn't heard it before, about Crestar and a credit report that you falsified.
It wasn't a credit report. It was letters to try to get something off of my credit report. So again, it was misconduct. It was giving myself permission to take a shortcut, right? And I'll solve this problem any way I can solve it. I think one of the things that, was so difficult was that Kurt was this deep intellectual, and as a corollary of that, had no practical skills, right? So that the business of running the family and the life and so forth fell to me. And after Carl's sickness, the encephalitis, that became really intense. And he and I, we sort of, in a sense, lived beyond our means. Kurt, I was consistently employed. Kurt could become employed or not, or be underemployed, because my father and I were always there to provide. And it was something at times I felt I was drowning in, right, to manage this. And at that time, I think I had 2 or 3 late marks on my credit report, and I was just trying to come up with some way to get rid of those. And I came up with this, I wrote a letter as if it was from a bank. I don't even frankly remember what the scheme was, but it was something dishonest. It was something fraudulent. It was not something I did before or since. I did not regularly cheat, lie, steal, do bad things. I mean, I was not in that sense. That wasn't sort of typical behavior. I mean, I think that day was maybe within a few days of that conversation with Mike where I'm sort of incoherent, right? But it was, I don't want to say a one-off, but it was wrong. It was wrong. It was not something that I felt represented me, and it was not something I was doing on a regular basis then. Does that answer?
Yes, it does. Was it successful?
I don't even remember. I do not even remember.
Okay, and this was all within that time frame before 1996. But let me ask you about the arrest in 2016. It was alluded to, but really not in any depth. Could you elucidate us on that
Yes.
arrest?
Yes, I had, and forgive me if I go on too long, as I said, we am.
No, fine.
I had gotten out by the late fall of 2015. I was, in December 2015, I was in the ER, and I was for chest pain, and they did a bunch of scans and found these aneurysms, right, way up high in the carotid. And we knew, as ODC intimated, we knew there was some kind of connective tissue thing in the family, even from the 90s, because everyone died from early death from aneurysm. And so we knew something was wrong, or tissue that ripped and tore real easily, like how my mother died. And so they found these. And as I said, my cousin had just died. And as soon as I said aneurysm, we were like, okay, I probably don't have long to live. I mean, that's just was our reaction, my brother and sister and I. And I was also having, problems with my stump, where I thought I'm 64. We're not supposed to say stump anymore. It's residual limb. But I was worried I was going to lose the little bit of leg I had left. And this was going into the spring. And I had didn't have the internship anymore. I'd applied for SSI, and I was pretty, I was pretty anxious, right? I think I've done well, but that's not to say it has been a process without stress. And at that time, I was having trouble walking. I asked Felix, my neighbor, to take me to Home Depot. I was returning something. I picked something off a $20 heat gun to buy. We went to a separate counter to return it, and I put both items down, meaning only to return the dowel. And he and I were talking, and she said, "Are you returning these?" And I said, "Yes." And I didn't mean for it to be both, but that's how she took it. And then she called the person over, and he said, "You're returning something you didn't buy." And I was sort of taken aback. And I said, "Well, no, I'm not." And we had some words. I think I probably was a little abrupt, but I was pretty anxious. And he then took me aside, and the conversation stopped right away, and he called the police. And at that point, I was just sort of terrified, because I thought, well, I'm going to get violated and remanded. I was still on supervision. So that's what happened there. It had never happened before, and it's never happened since.
Where I got a little bit confused, you were arrested?
Yes.
And I heard after that you had to take a class.
Yeah, I went to spoke with my legal aid lawyer, and he said he could do what's called an ACD, I think, or ADL, or I can't remember the letters, but it was an alternative disposition where it gets dismissed and you sit in and attend a class. And that seemed to me to be the wisest action to take, and that's what I did.
Okay, so were you charged?
Yes, that's in the questionnaire submitted.
Okay, thank you. In the questionnaire, as long as you mentioned it, there's question 28, I believe, asks, state whether or not petitioner intends to practice law in the District of Columbia if reinstated. And you said, "I am unsure."
Yes, that's true. I mean, at this point, I relocated to New York to be near the kids, right? And I have been sort of in a holding pattern, right? Pursuing some work while I was also resolving some of these medical issues and getting some assistance. And I still have connections to Washington DC. And
Sorry, you say you do have connections or don't?
yeah, I have family down here and friends still that I've been in touch with. So it was not at all outside the realm that I could return here.
Okay. So it is possible you'd be back practicing
Yes.
in the DC area.
Were I given that privilege?
Let me see. Well, I have a couple other questions, but I think you've hit on them all in your answers. I'm curious. You testified that the rights to citizenship were returned to you in Virginia, including the right to vote. And then you said, in DC, felons can vote. In New York, felons can vote. Have you voted?
Yes. I voted every election.
Okay.
I was a poll worker at this last election.
Are you a poll worker where?
This last election in New York, I did a day. It was great.
How can we be assured that you have the character and fitness to practice in DC, to be reinstated?
I think you can examine the truthfulness and credibility of what I've said to you in this hearing. I think the witnesses in support of me have no reason not to stand behind what they've said, no other reason to have said what they said. I think it's been 6 years now, 6 years plus, almost 7, that I've been out, and it's been sort of a consistent, solid pattern of growth and strength and problem solving and getting myself into a stable position. I think that's strong evidence. I think my contrition is real. My shame is real. I'm very sorry. I think that my pre-existing self, I would say, so the pre-Kurt area, right, where it was really, it was a deep honor and privilege, right? My father and I, as I said, it was understood that I was going to go to law school. That was be a lawyer. He wouldn't have had it any other way. But we loved it. We loved interacting in that way. We loved talking that way. We loved going to a march, going to we loved being involved. We loved staying up and watching an election. And all of that was so meaningful to me. And also my period when I worked at the NLRB was something that was very meaningful to me. I was so, I was George's daughter. I was like, oh, he'd been at the NLRB since forever. And I now was doing a good job there and well regarded. And I took real pride in that. And that's something that I feel that I tried also to pick up and continue, so that I've tried to take a lot of pride in what I do and do it well. I mean, even inside, as I said, even just the physical work, you take pride in it, you do it well. And that's something that was important to me. And I think I've shown that. I think that's an important element of character. I think being able to try to pick myself up from this and rebuild in and of itself is a pretty good indication of character. And I'll leave it at that.
It's a good response. Thank you. I have no further questions. Are any questions for Additional questions from the committee members?
I
Not
actually
from-
have, I do, I
I'm
have
sorry.
one more question. Ms. Squillacote, one of the things that came out through the testimony we've heard of the last couple of days, and particularly in response to the last question, was how you have used your skills. As the chairman said, there's no question that you are skilled as an attorney and what you've been able to do and the impact you've had. Have you thought about, or can you share with us any thoughts you have about your continuation of this work and the influence and the impact you have if you are not reinstated to practice? How do you think your impact will be? How do you think your work will be impacted? And what have you thought about in terms of continuing some of the very apparently helpful and impactful work you've done, thinking about the testimony from Attorney Valenti? So if you could share a little bit about that. What is life after, whatever after it is?
Sure. I mean, I think as I think I said in the very first question, I mean, being licensed as an attorney gives you scope, it gives you authority, it gives you the ability to impact that is sort of unique, right? That goes with that privilege of having a law license. That was what motivated me to want to be a lawyer to begin with. If I didn't, what would I do? I would continue to make whatever involvement I could in my community. I think, it's just, you don't have the same oomph, you don't have the same muscle, you don't have the same ability to impact. If I want to get involved in setting up a corporation to protect the aqueduct park, or if things like that, you have so much more scope if you're a licensed attorney. And in terms of prisoner rights, it's infinitely more advantageous to have the license, right? You can directly represent and assist, which I haven't been able to do, right? I can do it, sort of step back and do it in more indirect ways, but I could be more involved in the bar and in other, the ABA and in other professional organizations as an attorney that, you don't really have the same impact without it, or options. Does that help?
Yes, thank you. No further questions from me.
Well, thank you, Ms. Squillacote, for bearing with us.
Thank you.
Ms. Williams, why don't we take a recess till 11:30 and you can call your next witness.
I do want to reach out to them. I wasn't quite sure how long this morning would take, but yes, I'll use that time and we'll have that sorted out.
And who will be your next witness?
I want to confirm that. We only have 3 witnesses left, but I just want to confer for a few minutes.
Okay, very good. Thank you.
Thank you.
Opening up the breakout rooms now.
can still hear me, right, Joe? Like audio is good through the earpiece?
Yes. So we're still in the breakout room?
No, you're in the main session.
Okay, thank you. Sorry.
That's okay. If it was more than about the headphones, I would have chimed in.
I suspect there may be some puppy or pet maintenance involved in the delay, but my colleague should be back momentarily.
Ms. Williams?
Yes, petitioner calls Rosa Squillacote, please.
Letting her in now.
Squillacote? Good morning.
Good morning.
Do you solemnly swear that the testimony you will give in this proceeding will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you.
Good morning, Ms. Squillacote. This is Ms. Williams. Just so you can hopefully orient yourself on the screen.
Thank you. Hello.
In what city do you reside?
I live in New York.
What is your current occupation?
I'm an adjunct professor at CUNY.
Okay, and what kind of coursework do you teach?
I teach introduction to government, introduction to law classes at the undergraduate level.
And how do you know Theresa Squillacote?
She's my mother.
And how old were you when she was arrested?
I was 12.
And how would you describe the impact of your parents' arrest?
I mean, it was obviously very traumatic. It was very significant. It literally changed my life. Yeah, it was a big, big event.
How would you describe your relationship with your mother now?
Now we're very close.
And how would you describe your level of contact with your mother now?
We speak regularly, not quite every day, but she comes and watches my kids twice a week. So.
And just because these proceedings have been going on, have you watched any of the proceedings before
No.
joining? And were you in contact with your mother when she was in prison?
I was.
How can you describe that for us, please?
I mean, obviously it was a long time. And so the nature changed, right? When I was 13, you know, I'd see her more regularly. And we had more of a mother-daughter kind of relationship. As I got older, I saw her a little less often and we had more, I would say, like a friendly kind of relationship. So the visits were, you know, cumbersome to make, but we had good visits together. So.
And did you also correspond by email or letter while she was incarcerated?
Yes, we did.
And do you believe your mother feels remorse for her conduct that led to her conviction?
Absolutely.
And what's your basis for you believing that?
Well, one, she's told me several times, repeatedly. And then also I can see from how she has dedicated herself to her family, not only helping take care of my kids, but taking care of her uncles and cousins. She's always there when somebody needs something. And she's been very involved in community work in a church that she started going to after her release. So yeah, I see somebody who has very, very clearly demonstrated a lot of remorse.
And has she taken any actions to remedy her past wrongs?
Yeah, I mean, as I said, she's been very devoted to her family, in particular me and my brother. In particular, you know, she had a sick uncle out in California. She went and took care of him for a while. She's been spending a lot of time very dedicated towards repairing relationships.
And how would you describe your mother's behavior? Do you remember your mother from the time around when she was arrested in the 1990s?
I mean, obviously I was a child, so my recollections are going to be not totally complete. But yes, I remember my mom was very, I would say maybe chaotic, was very sort of like up and down. in terms of her emotions was not very stable.
And would you say the same thing now, or is
No. Yeah, no, she's definitely changed. She's a lot more, stable. She's a lot more consistent. She's incredibly reliable. Yeah, she's a very different person.
and are you aware of your mother seeking medical and mental health treatment currently?
Yes.
And does she do so consistently?
As far as I'm aware, yes.
And how would you describe your mother's character now?
She's a very strong person. She's an incredibly strong person. She went through an incredibly difficult time, and she's never let it defeat her. She's met challenges as they've come. She's, as I said, incredibly caring, incredibly reliable. I literally don't know what my family would have done without her since the pandemic started. She's been absolutely an incredible source of support for me. So.
And do you support your mother's petition for reinstatement of her law license?
Wholeheartedly.
No further questions for this witness. Disciplinary counsel and the committee members may have some additional questions for you. Thank you.
Okay.
No questions from disciplining counsel. Thank you.
Are there any questions from Ms. Smith?
I'm sorry, I forgot to unmute. No, I have no questions. Thank you.
Ms. Bunch?
I have no questions. Thank you.
I don't have any questions either. Thank you very much, Ms. Squillacote.
May I ask a question? Can I watch the proceedings now or no? Should I still not? Sorry, I don't know the rules.
I have no objection. I think it's disciplinary counsel will state your view.
When your mother's lawyers asked us about that, and it's really their call. But I think my view of it right now is that it's unlikely that there would be a need for you to be recalled. And given that unlikelihood, we wouldn't object to it. But but everyone just needs to keep that in mind.
Okay. Thank you very much.
No problem.
Have a great day.
You can watch.
Mr. Chair, would you like?
Next witness? Yeah.
Petitioner calls Michael Tiger.
Letting him in now.
I'm sorry.
Mr. Tiger, can you hear us?
Yes, I can hear you. Can you hear me?
Yes, but can you turn on your video, please?
Oh, how do I do that? Let's see. It should be.
I will send a request. Did you get a pop-up?
Here's a pop-up. The host has asked you. Okay, there we go. There I am.
Morning, Mr. Tiger.
Good morning.
Still morning.
Good morning, Mr. Browsist.
Brozest, right. Do you solemnly swear that the testimony you'll give in this proceedings will be the truth, the whole truth, and nothing but the truth? So help you God.
I affirm.
Fine, thank you.
I so affirm.
That's fine. Ms. Williams?
Yes. Mr. Tiger, this is Karen Williams. I hope you are able to identify my square and see me speaking.
Yeah, I can hear you, but I can't see you.
Okay. I think you can change your view to gallery, but I can proceed as is if you're okay.
Change my view to gallery.
Along the
Um,
top right-hand corner, there's something that says view. And if you click that, it
Oh,
should
there
give
it
you
is.
other
There it is.
options.
View. And then it says participants.
There should be an option for speaker, gallery, show non-video participants in full screen.
Or I don't see, I'm awfully sorry, I don't see gallery. I see participants, share, content, stop video, mute, and more on the upper right-hand corner. Let's see what there is over here. Oh, is that it? Oh, there we go.
Great. Just so you can see me, and then we are going to display one exhibit. So I just wanted to make sure you're on the right screen. Thank you for that, and we appreciate it.
I'm here.
Could you please state what your occupation is?
I am a lawyer, a law teacher, and a writer.
Where did you attend law school?
The University of California at Berkeley.
And are you admitted to the bar of the District of Columbia?
Yes, since 1967.
And are you familiar with the DC Board of Professional Responsibility?
Yes, I am. Go ahead.
How are you familiar with that organization?
Well, I've been a contact member for the past several years, and then I've served on 3 hearing committees, 2 dealing with charges of professional misconduct, and 1 dealing with procedural issues, and I am chair of hearing committee number 1.
And do you have any other bar admissions beyond the District of Columbia?
Yes, I am. Since 1994, I've been a member of the bar of New York. And then in terms of federal courts, I'm a member of the bar of the United States Supreme Court, the United States Tax Court, a half a dozen of the federal courts of appeals, several United States district courts. And from 1971 to 75, I was an associate member of the French bar.
And in what areas of law do you practice?
I have, in my law practice, I have done mostly complex litigation, both civil and criminal. That is to say, white collar crime, complex cases. And in that, on the civil side, multi-district litigation, complex cases. On the criminal side, white collar crime. I've been court appointed counsel in a number of capital cases, and also counsel in a number of cases involving national security.
And of the national security cases you just made reference, can you give us a couple examples?
Yes, the first such, when I first came to Washington, I was an associate at Williams and Connolly. And the first case I worked on became Ivanov versus United States in the United States Supreme Court. So that was somebody accused of espionage. And then in the Bobby Baker case, the Robert Baker case, there were national security secrets to which he'd supposedly been a part. In later years, I represented pro bono a defendant charged with espionage in the Eastern District of Virginia. And in the last year, my wife and law partner, Jane Tiger, and I have been expert witnesses in the United Kingdom to opine on the relationship between United States espionage laws, the First Amendment of the US Constitution, and Article 10 of the European Convention on Human Rights. And that was in the Julian Assange case.
And I believe you said earlier that you have been involved in teaching. Is that correct?
That's right. I've been full-time member of the faculty at UCLA, the University of Texas, Washington College of Law, and Duke University. And I've been a visiting professor at the Université Paul Cézanne. That's the painter, named after the painter. It's in Aix-en-Provence. And a lecturer at the historically Black law schools in South Africa during the apartheid period and thereafter, at the University of Paris and the University of Geneva.
And have you represented individuals who were convicted of crimes and then sought to restore their rights?
Yes, I have.
Are there any aspects of your criminal practice that you focus on in particular?
Well, you mean in relationship to the issues here? You know, in late over the last several years, I'm 80 years old now, so I mostly retired. But over the last several years, I focused particularly on this question of mitigation, redemption, and rehabilitation in the context of capital cases. My daughter is a physician and testifies as an expert witness in mitigation in capital cases. I've argued 2 mitigation cases in the United States Supreme Court. And so I teach and write and teach other lawyers about how we address this question of the whole person in the context of rehabilitation. And that's an aspect of what bars do, as I understand, in looking at cases of reinstatement.
And how do you know Theresa Squillacote?
I became aware of her case back when it was tried, although I don't think I met her at that time. Over the subsequent later years, she has called me several times to ask about getting an LLM, about her LLM thesis, which deals with lawyer-client privilege. And then, of course, back even before that, I was a fact witness in her Section 2255 case that was heard before Judge Hilton in Alexandria, and had some role in helping find a volunteer lawyer to do that case.
And do you recall the outcome of that case that you participated in? Was she ultimately successful in the relief she was?
I think she came in second. That is to say, Judge Hilton denied relief, and Judge Hilton denied relief.
And so I think from what you've said, it seems that you've stayed in touch with Ms. Squillacote since that hearing.
I have, and initially because I was interested in the issues in her case, and then as I got to know her, I became interested in talking to her and in corresponding with her about the let us say that the issue in which she was going to do her LLM thesis.
Okay.
Because that's a big one. Just I don't mean to go on, but in the United States there are 2 million people in custody in prisons and jails. The Supreme Court has largely written off the right of those people to counsel as a constitutional matter. And so this issue of the lawyer's relationship to and the with people who are the marginalized and incarcerated is important. And quite frankly, I've written an awful lot over the years about lawyers' role and responsibility.
And I believe you mentioned her LLM. Can you talk about Ms. Squillacote's interest in getting an LLM and why she was interested in getting an LLM, if she shared that with you?
She knew, I think she had some idea that she would want at some point to seek reinstatement to the bar. And in that context, she wanted to demonstrate that she had not just the competence to become a lawyer, but also that she was deeply interested in the most important questions that we have about the lawyer-client relationship. So in terms of its relationship to what's going on here, that was it. But also this question that she was writing about, that's a very important one, because there's a debate about whether the lawyer-client privilege is part and parcel of the Sixth Amendment constitutional right to counsel. Now, the European Convention on Human Rights, the European Court of Human Rights has held unequivocally, yes, it is, it's a matter of their law. But I just found it fascinating.
I want to back up a little bit for a moment and talk about how much you understood the offense conduct related to Ms. Squillacote's case. guess, what level of inquiry did you do into the underlying facts of her conviction?
I read the newspapers at the time, and then I read the Fourth Circuit opinion. And I refreshed my recollection about that in connection with the 2255. I then looked at this in the context of the issue she was presenting in the 2255 about her right to testify. So that's about it.
Do you believe Ms. Squillacote recognizes the seriousness of her misconduct?
I do believe that. Yes.
What's the basis for your belief that she does?
That I have talked to her over time about this issue. And I think, at the time of the offense of conviction, at the time the relevant conduct included her participation in the conduct at a time when she was a member of the bar. And so her returning, as I understand it, her returning to this issue, what are the lawyer's obligations? What are the rights of persons who have counsel? How can we expand the right to counsel? All relate to an inquiry into that. And so as I talked to her about that and about her hope that she can rejoin the bar and become one of those lawyers who does the important work of representing marginalized people, I come to the conclusion that I've expressed.
I'd like to display what's marked as Petitioner's Exhibit 9, and should appear on your screen in just a moment. Do you recognize this document, sir?
I do. I see that. I wrote that.
Okay. And is this a letter of in support of Ms. Squillacote's petition for reinstatement?
It is.
In your letter, you mentioned other cases with individuals with felony convictions that were either admitted or readmitted to various bars. Why did you include those cases?
Well, because we are inevitably in the common law tradition, we try to look at other similar cases to draw lessons, particularly in one that I think is potentially emotionally charged as this. So I thought that the case I mentioned, Roberto Maldonado, and indeed others I could mention, were important to that. Also, because I guess the hearing committee's task is to examine the case in light of the guidance from the board and the Court of Appeals.
Do you still agree with what you wrote in the letter? I know it was,
I do.
I think, about a year ago. Okay. And do you still support Ms. Squillacote in her petition for reinstatement?
I do.
I'd like to move for Petitioner's Exhibit 9 to be admitted into evidence.
No objection.
Admitted.
Mr. Tiger, are you aware of actions Ms. Squillacote has taken to remedy her past wrongs?
No, I can't say that I have, other than the fact that she's looked back into this obligation of lawyers and has written about it.
And you alluded to her thesis paper. So I believe you've already testified that you read it. Is that correct?
I'm sorry? Could you repeat that?
Yes, I believe you already stated this, but just to confirm, you read Ms. Squillacote's paper about
yes, her LLM thesis. Yes, indeed.
Yes, okay. And how did you assess the quality of the work of that piece?
Well, I think that George Washington was right, if I remember correctly, if they did, that's worthy of an LLM. That's important work, especially, as I say, because it addresses this question of the 1 in 36 people that are marginalized by being incarcerated in the United States. And that's just talking about, without getting to the question of people of color being disproportionately incarcerated.
Do you believe Ms. Squillacote possesses the qualifications and competence necessary for admission to the DC bar?
I do. And do you want me to say why, or just answer? Yes. I do.
Yes, please.
Well, I start I think I take the question as right now in the present day, has she demonstrated those qualifications? And so I say yes, over the past several years and down to the present day, she has. And then I take account of the offense of conviction. And the offense of conviction represented some very serious violations of the statutes and arguably of her obligation as a lawyer. So we have to ask ourselves, well, what do you think about that? And the first thing I think about that is that it is clear to me from reading her papers that she sees the lawyer's obligation and intends fully and unqualifiedly to fulfill it in an honorable way. And so much time has elapsed. This was a 20-year sentence, which I think was just grossly excessive, by the way, at Judge Hilton. But anyway, we won't get into the Eastern District of Virginia. That this is kind of therefore like some other cases. You know, Clarence Darrow, I talk about Leopold and Loeb in the letter. I won't repeat that. Roberto Maldonado, who I knew, was readmitted to the bar of Puerto Rico after being convicted of conspiring to hold up that bank in Connecticut on behalf of the independentistas of Puerto Rico. And they let Roberto Jose back in, even though the United States Justice Department was pushing against it. And another one that I don't mention in the letter, but I think is relevant, is Alger Hiss.
I'm sorry. You know, Mr. Chair, you know, I've been trying to just give some leeway. You know, Mr. Tiger's a character witness here, but I think the testimony is getting a little far afield from what Mr. Tiger was called here to testify according to the witness list, which was essentially limited to his testimony related to Ms. Squillacote.
Well, I think what Mr. Tiger was doing was looking at comparable cases and the reinstatement. Is that correct, Mr. Tiger?
Yes, and I'm on the last one of three, if that's any comfort to anybody.
Why don't we just hear that and apologize. Why don't we hear that and we'll move on.
All right. Well, the third case is Alger Hiss, who was readmitted to the Massachusetts bar in 1975. Now that I knew Mr. Hiss and a little bit, and I knew particularly his lead counsel, Victor Rabinowitz, who'd been litigating the cases. What's significant about that case is that Mr. Hiss gets back in the bar, even though he doesn't express remorse about the alleged conduct. And I thought, so I take that as relevant. It was a present day look. And as I say, I knew him slightly and I thought that was a correct decision.
What was it in the
Because
District
it seemed-
of Columbia? Was it the DC bar?
No, this was in Massachusetts,
Okay.
Mr. Chair. But the opinion of the court, which the court can look up, is, I think, the analysis is very significant. Because to impose a requirement that someone confess guilt in order to get reinstatement raises a set of difficult legal questions. That was
That's not before us today.
I understand it's not before you today.
Okay, great.
Mr. Chair, if I receive, did you have another question?
I don't have another question.
Do you have any concerns regarding Ms. Squillacote's ability to maintain client confidences?
No, I don't.
How would you describe her demeanor when you have interacted with her?
I only interacted with her in person once. So demeanor, we have to look at all of the email and telephone conversations. I think she's just extraordinarily serious and diligent about understanding what's going on.
Are you aware of any behavior by Ms. Squillacote since her conviction that for you would put in question her allegiance to the United States?
No, I'm not.
And I think you've already covered this, but you still support and recommend her readmission to the DC bar.
I do.
No further questions. Disciplinary counsel and the committee may have some more questions for you, Mr. Tiger.
Thank you. Mr. O'Brien, is it your witness?
Good morning, Mr. Tiger. I just had one clarifying question. You said on your direct testimony that you talked with Ms. Squillacote over time. In the course of this proceeding, petitioners offered a declaration where she indicates that she consulted with you about her criminal case before the criminal trial. And I just wanted to ask you if that was consistent with your recollection or not.
I don't have a recollection of a consultation, right? But I'm 80 years old, and it's a long time ago. But I do have a recollection that I was very concerned about the case, and that I had tried an espionage case representing a defendant out there in the Eastern District, which is where the government puts all of them. So it is not at all surprising that she would have called me about at that time and on that subject. So I have no reason to doubt.
That was the only question that I had. Thank you.
Ms. Smith, do you have any questions?
I'm so sorry. I have no questions. Thank you.
Thank you. Ms. Bunch?
I have no questions. Thank you.
Mr. Tiger, I just have a few questions. You indicated you tried an espionage case in the Rocket Docket.
Apparently you're familiar with it. Yes, it was United States versus Trong, Truong, and we tried it in the old courthouse before they moved the new one in front of Judge Bryant.
Thank you. You said something about that, which I found interesting, and I'm reading from your letter. In an espionage prosecution, the 4th District includes Virginia, the prosecution is free to introduce evidence that materials provided to a foreign nation are classified as relevant to whether the defendant caused injury to the United States. Your next sentence, however, the defendant is not allowed to question the propriety of classifying the materials. I found that as a very interesting statement, in that how does a client, or I'm sorry, how does the petitioner demonstrate their rehabilitation or whatever if they're challenging the very classification system that they violated? Do you understand what I'm saying?
I understand, and Mr. Chair, that's a central problem in all of these cases. I think in assessing the seriousness of the conduct, we have some guidance. There's a statute from 2010 that deals with overclassification. There is, Solicitor General Griswold's statement that there was gross overclassification in the Pentagon Papers case. But we're left, it seems to me, that if in these criminal cases, the government does not shoulder the burden of justifying classification decisions, and if we know from statutes that classification, there's gross overclassification, that that is a weakness in any allegation about harm.
The documents in this case were classified, and I don't think there's been any testimony that classification was inappropriate.
I don't know one way or another.
Okay. So
I'm prepared. My opinion accepts the judgment of the jury and the Court of Appeals about the judgment of conviction. I don't retreat from that a bit.
Okay. And based on that, you think in your conversation, the respondent, the petitioner, has demonstrated the contrition for her acts?
I believe she has demonstrated that she is ready to fulfill the obligations of a lawyer. I have never discussed with her whether or not she believes that the jury's verdict was righteous or not righteous. I was simply interested in, this is a profession whose values I care about very, very much. And I was concerned about the here and now.
So, and I agree with you, but it's important to recognize that the lawyer, or Ms. Squillacote, in this instance, violated the confidences of her client.
Yes.
And what we're here today trying to decide is whether going forward that won't happen again.
It is my opinion that accepting that the judgment of the jury and the Court of Appeals, that there is zero likelihood of her failing to respect the confidences of her clients. And you could say there's zero likelihood of her reoffending.
Okay. Well, thank you, sir.
Thank you.
Are there committee members have any further questions?
None from me.
You're excused, Mr. Tiger. Thank you for your time.
Well, thank you very much, Mr. Chair. Thanks also to the members of the committee.
Thank you.
Ms. Williams, are you prepared for the next witness?
That is the last witness we will be calling, Mr. Chair.
I see. So what we have left is the closing. Should we take a lunch break before the closing? Would that be suitable to the parties?
And I was just going to suggest, Mr. Chair, the other thing that we talked about is disciplinary counsel does need an opportunity. We've been assessing the evidence as it comes in live through petitioner's case. We do need the opportunity to consult with our office about before closing. And I also just wanted to.
We do hope you will have a position.
No, I think there's two things that we have to assess, Mr. Chair, that we talked about yesterday. The first is whether there's a need to put on evidence in disciplinary counsel's case, because we're just at petitioner's case, and I understand. Has petitioner rested her case? Is that right?
Yes, petitioner rests.
And so the two things that we have to talk about is whether it's necessary to put on any evidence in disciplinary counsel's case in chief, and then for closing, precisely what recommendation disciplinary counsel is going to make. And I was just going to suggest a lunch break would be very helpful for us to do those things.
Sure.
I'm sorry, Mr. Chair, just to clarify, I know I did say we rested. We haven't discussed it. I just wanted to state for purposes and a reminder for the committee, there is a stipulation that we consider part of the record and part of the petitioner's case, but we're not discussing it in the proceedings.
Oh.
So how would you like to proceed with that?
I think it's already admitted in the record. I just wanted to note it just to ensure that everyone recognized it was part of petitioner's case.
And disciplinary counsel will just say, for purposes of the record, that its understanding is consistent with what Ms. Williams has said, and we're referring to the stipulations that have already been submitted. Is that right?
Correct.
Yes.
Right.
Yep.
Okay, and the chair appreciates the way counsel has worked this case together. We will take a break, and I know, Mr. O'Brien, you've got some things to do, and hopefully it will be a position, as well as whether you are going to put on other evidence. Can we say maybe 1:15? Does that work?
Yes.
Ms. Williams?
Yes, that's fine. Thank you, Mr. Chair.
Wonderful. Great. Okay. Have a nice lunch, everybody.
Thank you, Mr.
Opening
Chair.
up the breakout rooms now.
Who will that be? Oh, we can talk about it later. Are we all assembled?
I feel like we're missing Miss Smith
I'm
Or-
on. I'm,
or her video.
Yes.
Yeah, she is by phone, as we agreed.
Sorry.
Good.
Okay, I am on.
Okay, thank you, Ms. Smith.
Sure.
Are we ready?
Disciplinary Council has discussed, well, I'm sorry, if the chair is ready to proceed.
I just want to make sure. Yes, we're ready to proceed. Do you have a matter before closing?
Yes, just two quick things. Disciplinary Council has conferred and is prepared to give its recommendation to the committee. Mr. Perry will be handling the closing argument. Before that, there was just very quickly, there was two issues. The first is that Disciplinary Council thinks that it needs to put in, well, one exhibit that it overlooked during the examination, which was Disciplinary Council Exhibit 49. If petitioner wants to take a minute and determine whether or not they would have an objection to that being admitted, we can either, that can either be admitted on stipulation, or Disciplinary Council would ask that it briefly have the opportunity to ask Ms. Squillacote a few questions about that exhibit.
That's the trial transcript of Douglas Gregory.
Who I understand it was the undercover agent. Is that right?
So just to clarify, so you don't wish to inquire of that transcript with Ms. Squillacote, you just want to admit it?
Well, I'm saying those are the options. It could either just be admitted, or if petitioner objected to that, then Disciplinary Council would just ask Ms. Squillacote a few brief questions.
Just to authenticate the document.
Essentially, yes.
May I have just a brief moment to
Sure.
confirm?
Sure.
I'm going to mute us and turn my video off for just a moment.
I think we need to turn off Ms. Squillacote's video too, if that was your intention.
So Brian, is there a question or anything else on any of the other documents?
There's one more issue, but I think I'll wait for Ms. Williams to come back.
All right.
Thank you for your patience. I apologize for that. We will stipulate to the introduction of that exhibit without testimony.
Okay, so exhibit 49 is admitted.
And then the second issue is one that Disciplinary Council raised on the break as it was discussing whether or not there was anything else necessary. There's one, I will subjectively refer to it as a minor issue. Disciplinary Council was not able to raise it to Petitioner's Council until just before the call. But what I would suggest is what I think makes the most sense is perhaps if the hearing committee could leave the record open for a limited purpose for 24 hours. And there's one issue that Disciplinary Council believes that it could work out with Petitioner's Council, and it would either be the filing of a stipulation or the filing of a motion by disciplinary counsel, subject to petitioner's objection, to file one supplemental exhibit about the issue if the parties could not reach a stipulation.
Have you tried to reach a stipulation?
Oh, so unfortunately, the district council and I want to be clear in discussing the issue of whether it needed to call its case in chief, came to this issue and did not raise it into petitioner until 20 minutes ago. And so it wasn't enough time. District council's reached out. Petitioner just hasn't had the time to be able to look into that issue, I think. But I'll let Ms. Williams.
Yes, another attorney on our team alerted me to the email, but I candidly have not even read it yet myself. I was preparing for closing. So I just think we need an opportunity to confer. I'm happy at the committee's preference. It makes sense for us to take a brief break and see if we can resolve the issue now. I'm happy to do that now. However you prefer to proceed.
I would prefer to do that rather than keep the record open for 24 hours. Would you guys like to close and then take some time?
I think that's fine. I will ask, if possible, could we have just a 5-minute break before closings? But if we are going to do closings first, that's fine.
You want to take a 5-minute break when? Before now or after?
Yes. If you would like to proceed with closings now, that's fine, but I would just like to take a brief moment before we do that.
Dealing with this specific issue or something else?
No, just to frankly take a comfort break before.
Oh, certainly. Go ahead. We'll take a break, 5-minute break.
I will open up the breakout rooms for everyone again.
You guys.
Why don't I call big picture.
Are we now ready to proceed? Everybody there?
I cannot hear yet. Hold on.
It's always this lag.
Yeah.
Who's not here? I'm sorry.
Ms. Williams needs just a minute to, for the audio visual.
Can you hear us now?
Yes.
No, I'm talking to Miss Williams. Can you hear us now? No?
Can you hear me?
Yes, we can hear you. Can you hear me?
I cannot hear you, anyone else yet. There seems to be a lag sometimes. I'm going to mute and unmute and see if that fixes it.
How about now? Can you hear me? Hello? Hello? Can you hear me now?
Can you still hear me now?
Can you hear me yet? Miss Williams? How about now? Can you hear me?
I'm chatting with the board to see if we can resolve this. Apologies for the delay.
Can you hear me now?
Yes, thank
Okay.
you. Apologies for that.
Okay, we're good.
Yes, Mr. Chair, thank you.
Okay. Well, you know, I started off by saying there were going to be glitches, and there are glitches.
I think it's just something out of the break room, but yes.
Okay. Upon reflection and talking with the other committee members, we would prefer if you took a recess now and tried to resolve this issue before closing.
I think we actually have it. We multitasked on the break. I think we, though it was short, I think we accomplished both on the break. Mr. O'Brien, do you want to, I think the issue comes from at the beginning after disciplinary counsel's opening statement. I made a remark noting that there were medical records in the evidence already. There was a report and a letter that we used during the course of Ms. Squillacote's direct examination. I pointed that out not to disagree with what disciplinary counsel had stated, but just simply to acknowledge there were medical records in the evidence, even though a medical expert was not being called.
Okay.
And to maybe be a little bit more clear, you know, the issue, it's difficult because we don't have a transcript, but the issue was that disciplinary counsel's recollection was that, you know, the statement that was made was that petitioner's counsel was confused by my representation in opening about what we had disclosed about the lack of medical experts and records. And I just wanted to make it clear that I think the parties agree that on November 29th, we had discussed and specifically confirmed an email that given the petitioner's underlying mental health matters that were asserted in the criminal case and again reasserted in the petition, we discussed and confirmed an email that it was an issue whether Ms. Squillacote could prove rehabilitation and fitness by clear and convincing evidence without an expert witness to testify about those issues at the reinstatement hearing, subject to cross-examination and examination by the committee. And that was the only issue that I wanted to make sure was clear on the record.
And okay, Ms. Williams?
And I'm fine with the representation he just made. So I think we are in agreement.
Excellent. So with that, we're able to proceed to closing.
Yes.
Ms. Williams?
Thank you, Mr. Chair. First, on behalf of Ms. Squillacote, myself, and her other pro bono counsel, I would like to thank the committee for its time, attention to this proceeding, and thoughtful questions. We recognize that this is a case with a long history and that you have been presented with a lot of facts and documents. Petitioner now asks that this committee recommend her reinstatement to the Bar of the District of Columbia. She has satisfied her burden and provided clear and convincing evidence as to all 5 of the Roundtree factors. I'm going to begin with the last factor first because it seems that there's little debate as to that point. Ms. Squillacote possesses the present qualifications and competence to resume the practice of law in DC. She has done research work for legal professionals in supporting herself since her release. She completed her LLM degree at George Washington University Law School. She wrote an LLM thesis that was thoroughly researched and well regarded by others. And she also scored well on an NPRE exam in March of 2020. As to the first two factors, the nature and circumstances of the misconduct and the recognition of the seriousness of that misconduct, Ms. Squillacote repeatedly acknowledged her actions, the seriousness of her actions, and her deep remorse and shame for her behavior at that time. That behavior did not reflect her authentic self, which she has now refound and embraced. She calmly and politely answered questions for multiple hours about her conduct in the 1980s and 1990s that led to her serving almost 2 decades in prison. It is the committee's duty to assess credibility, and Ms. Squillacote has answered all questions to the best of her recollection and without minimizing her culpability and responsibility. She hopes that her deep contrition shows through. Fourth, I'd like to briefly address her conduct to remedy past wrongs. Ms. Squillacote began working to remedy her wrongs while incarcerated. She is not a person who waited until she was released to take a different path in her life. She rebuilt her relationships with her family. She rebuilt her relationships with her community, whether that was a community in a prison or in a Brooklyn halfway house or in the Bronx. She worked jobs and took extensive programming while in prison. She joined a church community upon release and began further engaging in social justice efforts. As testified, she was committed to helping others in whatever way she could and can now. The most important conduct, however, to remedy her past misconduct ties directly to the final factor, her present character. She described in detail the painful and difficult work that she has done to work on herself. She has reflected on her past misconduct and her issues with mental health in order to ensure that she does not repeat her past errors of judgment. Ms. Squillacote presented various certificates for different therapy programming that she participated in while incarcerated. She also described the life-changing cognitive behavioral therapy that she received through the RDAP program and the skills from that she continues to use today. She demonstrated a continuity of care as to her mental health and an intention to continue that care moving forward. As to the committee's concern about her ability to maintain client confidences, she testified about her decision to take a legal ethics class in completing her LLM because she found that to be important and relevant to her past misconduct. You also heard from many witnesses who described Ms. Squillacote as she is now. She's motivated, kind, professional, and acting with integrity. Reverend Morgan, for instance, trusted Mrs. Squillacote as acting as a representative of the parish in the community and gave her tasks that required sensitivity and good judgment. Multiple individuals have noted Ms. Squillacote as motivated and on a positive and stable path in her life. Those included her medical health providers in the letters presented during her testimony, as well as her probation officer who supported her early release from supervised release. Ms. Kramer also testified and works regularly with individuals re-entering society after incarceration and described Ms. Squillacote as courageous and reintegrating herself in a way that exceeded many.
Ms. Williams, can I interrupt for 1 second?
Sure.
You know, I'm sure in the legal profession, it can be very, very stressful. In your situation now in litigation, what measures are there in place to ensure when stress emerges for the lawyer, as it inevitably will, that she can cope with that stress and not deal in a manner inappropriately?
For Ms. Squillacote in particular, or just generally?
No, for Ms. Squillacote.
So, yes, Mr. Chair. So I think she's developed a sense of community. She has a great number of resources available to her Ms. Kramer, for one, the parish community that she, even though she now lives in the Bronx, she still stays active in. She's reestablished her relationships with her family. I think testimony that was very indicative of the type of person Ms. Squillacote is and relates to this issue is Reverend Warden. When he testified about seeking input from her for doing inmate efforts. Ms. Squillacote did extensive research and provided that to him. I think her resourcefulness and ability to identify and find resources, particularly as she's been reestablishing herself upon her reentry, shows her ability to find resources when she needs them and take advantage of them. And that through the work that she's done, I think in her description of the RDOT program, she talked about basically analyzing your thoughts and building that skill set in a way that if she's having problematic thoughts, she knows the signals of that, and she's regularly seeing her mental health practitioners so that they can assist her as needed in doing that.
Thank you.
Just in closing, I wanted to say that for the period of time, Ms. Squillacote, the behavior that Ms. Squillacote engaged in was truly reprehensible. Our society is one of redemption and second chances. We believe that she has demonstrated that she deserves the opportunity to be a lawyer again, based upon what she has done with her life since the offense conduct. Thank you again for your time, and I'm happy to address any other questions the committee may have.
Thank you, Ms. Williams. I'm sorry, Mr. O'Brien or Mr. Perry? Mr. Perry.
Mr. Chair. May it please the committee, having reviewed the evidence and testimony as much as that is possible in real time, we will be recommending to you that petitioner has not met her clear and convincing burden in this matter. At this point, we have identified at least 3 areas of concern. The first goes to character witnesses, and speaking generally in characterizing their testimony, it didn't seem that they had much of a grasp on what petitioner had done. And obviously that's on a spectrum, maybe some a little bit more, a little bit less than others, but they didn't seem to have a full grasp of kind of the scope of the misconduct, but were simultaneously giving assurances that it would never happen again. And that just doesn't seem logical. You can't talk about how far someone has come when you don't know exactly where they're coming from. And that seemed to be a problem, at least to some extent, with all the character witnesses. Relatedly, a second area of concern goes to the recognition of seriousness of the misconduct. And we, just over the course of the past 2 days, looking at testimony both on direct and in cross, and looking at petitioner's petition that started these proceedings, we see some inconsistency in petitioner's testimony, extending to not just the level of seriousness of the misconduct, but even to whether certain things were associated with her misconduct at all. And thirdly is the mental health component of this case. I mean, obviously, I'm saying this to you now in the context of Mr. O'Brien and Ms. Williams just talking about how at the outset of these proceedings, Mr. O'Brien noted that disciplinary counsel had raised it with petitioner that we had some concern of whether she could establish by clear and convincing evidence that she was ready to resume the practice of law without any sort of expert testimony subject to cross-examination on the mental health topics. And past that, the record over the past 2 days seems pretty clear that petitioner is asserting she had a very serious mental health issues and she is asserting that they bore some level of influence on her misconduct. If we take that as true, then it naturally follows that the committee needs to be reassured that those issues are being adequately managed. And given the seriousness of the issues that we're discussing, major depression, borderline personality disorder, narcissistic disorder, grandiosity, I believe is the fourth. Given the severity of those conditions, hearsay letters, when you even have one of the petitioner's own experts in the underlying trial testifying about how hers is a complicated case, hearsay letters are not clear and convincing evidence that those conditions are being adequately managed.
But Mr. Perry, she in her testimony has indicated the measures she has taken. You know, she's in therapy, she's on medication. She's in these she's had these courses, or not courses isn't the right word, but what would it take for you to be satisfied?
Certainly, and I'll answer that question as best I can. First, with
I don't mean you, I mean disciplinary counsel.
Certainly, and so first, I would say this is in the context of this one concern, and as I'm hoping to lay out, we've got at least three. But on this one point, one thing that you would want to know is that the diagnosis of stability was coming from someone who was fully apprised of what was going on, had all the facts of petitioner's case. And just like we saw with the character witnesses who didn't seem to be fully apprised of all the facts of petitioner's past actions, we would want to be assured that any mental health professional truly understood the scope of these problems, and with that knowledge could in turn say that it's being adequately managed. And we've seen in the record that, you know, not only these problems potentially manifesting in what we've kind of all been focused on, the espionage, but we also have that other issue of how, at least her expert testifying that this condition was manifesting itself in connection with sort of credit card fraud, or fraud in the pursuance of getting her credit report corrected, I should say.
Right.
And this is petitioner's burden, and her burden is set against the backdrop that she faces heightened scrutiny given the nature of her misconduct, which, it bears mentioning, involved her and a foreign intelligence agency starting in approximately 1979 and into, I think, her mid to early 30s. None of what the Office of Disciplinary Counsel is saying obviously should be taken as a rejection of the steps that Ms. Squillacote is taking or has taken to address her mental health and better her personal and professional life. However, given the context of this case and the heightened scrutiny involved, and that we can already discern three somewhat discrete areas of concern, we will be recommending that petitioner has not carried the significant burden that she faces before you in our briefing.
Thank you, Mr. Perry. Ms. Williams, any rebuttal?
Yes, Mr. Chair, thank you. As to their first point about character witnesses, I would just go back to the factors, and the factors are present character. And the character witnesses called were all individuals who have interacted with Ms. Squillacote in her present environment, some going back to when she was incarcerated before, but they reflected on her present environment. And our position would be they had enough knowledge of her past misconduct to make value judgments as to how much trust they wish to extend to her. And the individuals over and over stated that the way she conducted herself now was with integrity, and they did not have concerns about her character at this point. We believe that's significant for the burden that she carries as to that point. As to the seriousness of the misconduct, we leave that to the committee to evaluate the testimony. Ms. Squillacote, testified for a very long period of time. Going back to your past question about stress, I think that was a stressful situation. She tried to answer those questions as best she could. It's been a long time ago, so knowing all of the facts may not have been possible given the lapse of time, but she answered the questions as best she could and repeatedly said, even with her mental health issues, that didn't absolve her from the wrongness of her conduct. As to the mental health issue, I want to go back, I guess, to my opening statement where I alluded to the fact that Ms. Squillacote would be open to conditions. She doesn't, under the law, we understand that she must prove that she's fit to resume the practice of law. But if the committee finds that it would be appropriate, she would be amenable to some kind of condition where she has to report in that she is continuing her mental health care if the committee thinks that's appropriate and necessary. As to the evidence that was presented, I do want to just mention to the committee for your knowledge that there is a limited subpoena power associated with these proceedings. Ms. Squillacote's treating physicians are located in New York, and based upon the policies of the institutions where they worked, they cannot voluntarily appear. So we were stuck a bit in a hard place as to that, and why we relied upon the letters they had previously provided.
Well, I'm glad you added that. I wasn't aware of that fact.
We did confer with disciplinary counsel as well as the Office of the Executive Attorney about that issue to see if there was a way to issue a subpoena. But at least as to my understanding from those conversations, New York would not necessarily honor or recognize a subpoena from the Board of Professional Responsibility.
I apologize, Mr. Chair. If I could respond to that, please. I find myself in the position of having to maybe restate the position that was just stated. The parties shared expert witness lists. I believe I'm going off the top of my head. I believe it was November 23rd. There were 4 treating physicians that were identified on that exhibit list. Disciplinary counsel had no knowledge about anything. After the expert disclosures, those expert disclosures were much earlier. Those were in October, sometime in October or early October, when disciplinary counsel had the expert disclosures.
Is that like Ms. Hope? She was one of Dr. Hope, I think.
Dr. Hope, yeah. Tompkins, and 2 others that I can't recall.
Yeah, I remember.
That was in early October. After the exhibit lists and witness lists were disclosed on November 23rd, that was the point at which disciplinary counsel raised with petitioner's counsel that even though there had been 4 experts that had been disclosed, none of those experts appeared on the exhibit list, and it appeared that there was an additional expert, last name Crocker, I believe, or disciplinary counsel incorrectly believed that it was a medical expert. At that point, that was the time that disciplinary counsel raised with petitioner and said, through counsel, and said, we have concerns, number 1, about there being a medical professional who wasn't identified on the expert disclosure, and 2, and the petitioner clarified that Ms. Crocker was not a medical professional. She was only going to be testifying about re-entry issues because she was a caseworker for an insurance company. And at that point, that was the point that disciplinary counsel disclosed to petitioner's counsel, said, well, we have these concerns that without any medical professional, that Ms. Squillacote will not be able to carry her burden. After that, the subpoena issue that Ms. Williams just referenced was solely related to Ms. Crocker. that there was no discussion with disciplinary counsel about any subpoena issue related to about not being able to subpoena the witnesses, and disciplinary counsel tried to assist petitioner's counsel in figuring out if there might be a way to subpoena Miss Crocker, but that was what it was limited to. And I'd also like to say, since the treating physician issue, other than not being apprised of it until after exhibit and witness lists were disclosed, and after disciplinary counsel was expecting, based on the expert disclosures, that those would be the individuals who are testifying. That's something that is almost wholly within petitioner's control. Petitioner has said that she might move to Washington, D.C. It's possible to see someone who's licensed in both D.C. and New York. It's possible to see a physician in New York who, for a medical provider who has offices in D.C. that would have a registered agent. I don't see how this is really relevant.
No, I understand perfectly, Mr. O'Brien, and I understand the burden in a reinstatement action is clearly on the petitioner. So let's leave it at that. I mean, the evidence is in. Were you finished, Ms. Williams, with your rebuttal? I don't think so.
Yes, Mr. Chair, that's fine.
Okay. I think we're finished. But before we address the post-hearing briefs, have we reached agreement on the disposition of all the exhibits? I think we've been pretty good, all parties, in moving the evidence for admission. Any questions on any exhibits? Because I don't want to deal with this after we wrap up. Ms. Williams?
Further from petitioner.
I'm sorry, did you say no?
No.
Mr. O'Brien?
No other issues. I think the parties have to confer to, and I think we can just provide the stipulated statement.
Exactly. Okay. There are no other issues for the parties to resolve. Is that correct? I mean, we got into that discussion, but there's nothing to resolve there.
No. Simply for the, Mr. Chair, if you'll give me just a moment, I don't disagree with what Mr. O'Brien was saying as to when we escalated the subpoena issue to him. I will say, we were working diligently on our end. It did not present itself that we were going to have that roadblock presented when we disclosed the experts. And that is why I continued to have conversations trying to find a way to resolve that. And that is why we tried to get Ms. Crocker's participation, but also we're not able to get hers. So I hope that doesn't require more follow-up from Mr. Bryan. I hope he agrees with that, but I just wanted to clarify that perspective that he didn't necessarily.
That's fine. I think both parties presented their case very well. And I appreciate your cooperation. Let's discuss the post-hearing briefs. And I think you sort of know kind of what we're interested in. Certainly, we would like you to focus on the Roundtree factors and relevant testimony and evidence going to those 5 factors. Also, the disciplinary rule 11, section 16D talks about requirements for reinstatement. And I think you should focus your attention on that. as well. I'd like to say this too, for petitioner. One of the things we are struggling with in the committee is the petitioner has committed some very manipulative and duplicitous acts in her past. And we would like you to address everything that has been done to assure us that if she is reinstated to practice law, that she does have the qualifications and character and fitness that is necessary. So if you could focus on that, Ms. Williams, it'd be most appreciated.
Understood, Chair. Mr. Chair, thank you.
As to the briefing schedule, based on Rule 12.1, it provides that petitioner file his or her brief 10 days following service of the hearing transcript. Assuming the transcript is released in 2 weeks, which would be December 22nd, that would make petitioner's brief due on January 10th. So you'd have to do some work over the holidays. Is January 10th an acceptable day for you, Ms. Williams?
It is, Mr. Chair, if possible, given the holidays, would it be possible to have until January 14th, the end of that week?
Yes.
Disciplinary council, we could, consent.
Okay. So we're putting you down for the 14th. And I don't have my calendar in front of me. So what would be 10 calendar days after that? Do you have that, Mr. O'Brien?
January 14th, and then 10 calendar, that which is, I have that as Friday, January the 14th, and then Friday, January 28th.
28th. Is that an acceptable day for disciplinary council?
It should be, yes.
Okay, because we don't want to deal with, motions, we need 3 more days. If you think that's good, let me know.
Well, the only thing that I'm concerned about is I'm trying to recall all of the school days and I believe there's a couple actually in those 2 weeks. If we could have till the Tuesday, February 1st, I think that would make sure that we don't have to. We're not looking for other additional time.
And can I just clarify, Ms. O'Brien, the date of the 21st date was 10 business days, not 10 calendar days, correct?
Yes, I got confused. No, yes, I was doing 10 business days, so I was calculating 2 weeks from the 14th. So so 10 business days to the 28th is what I was doing. Is that what I was supposed to do?
Yes.
Oh, okay, good.
I thought the ask was for 10 calendar days. So I just wanted to make the record clear that we're looking at 10 business days.
Sorry, I knowing the rule, that's what I heard. Thank you.
But you can live with the first.
That would be great, Mr. Chair. Thank you.
And then 5 business days for petitioner to file her reply brief.
And we would consent if petitioner would like a few extra days there as well.
You guys think I'm soft?
I should make clear, it is not our decision to make. We just wouldn't object.
So just catching up, I realized we floated a couple of days. So disciplinary council's response will be due February 1st. Is that where we are?
Right.
Okay.
And I was going to set February 8th for the reply brief.
If we could have a couple more business days, that would be appreciated. So I guess I keep going to a Friday. Would it be possible for us to have until February 11th?
Well, that's a big jump.
Or the
How
10th?
about to the 10th? Let's do that. Okay, a briefing order will follow, memorializing these details. And I want to thank the parties. Ms. Squillacote, thank you for your time and patience in this matter. As you can
Thank you.
tell,
Thank
Yeah,
you.
t-
Thank you for listening, paying attention. I appreciate it.
yes, ma'am. And be advised that we are taking this very seriously.
Yes, sir.
And we will consider everything. And with that, I believe this hearing is adjourned.
Thank you.
Thank you.
Thank you, Mr. Chair, members of the committee.